Oath of office and surety bond. In this lesson, you'll learn the final steps that complete your commissioning as a notary public, taking the oath of office and securing a surety bond where applicable. These legal steps officially authorize you to begin your duties and ensure you uphold your responsibilities. For our first lesson, we'll talk about what is the oath of office. The oath of office is a formal declaration in which a newly appointed notary public swears or affirms to faithfully perform their duties according to the law and without bias. This oath is usually required by state law before you can officially begin acting as a notary. It may be sworn before a county clerk, state official, or judge, depending on your jurisdiction. What do you promise in the oath? To uphold the Constitution and laws of your state and the U.S. To act with honesty, impartiality, and integrity, and to avoid conflicts of interest or misconduct. Common mistake. Failing to file the oath within the required time frame, often 30 days from appointment, can result in forfeiting your commission. For our next lesson, we'll learn how to take and file the oath of office. Here's the step-by-step procedure. Receive your notary commission certificate. This is issued after your background check and application approval. Some states mail it, others notify you to retrieve it online. Schedule your oath appointment. Contact your county clerk or commissioning agency to find out where to take the oath. Appear in person and take the oath. Bring valid ID and your commission certificate. You'll be asked to raise your right hand and swear or affirm to fulfill your duties. Sign the official oath form. You will sign in the presence of the administrating official. File the oath with required offices. In most states, this must be filed with your county clerk's office. Some states also require a copy to be sent to the Secretary of State. And last, pay a filing fee. Fees vary, but are typically modest. Exam tip. You may be asked, where must a notary public file their oath of office? Answer depends on your state, but county clerk is common. Next, what is a surety bond? A surety bond is a financial guarantee that protects the public from financial harm caused by a notary's mistake or misconduct. It is not insurance for the notary, but a form of public protection. This typically ranges from $5,000 to $25,000 and costs between $30 to $100, depending on coverage and term. It is required in most states. Who are the parties involved? Principal, you, the notary, surety, the bonding company, and the obligee, the state or public. What it covers: unintentional errors, fraudulent acts, and failure to perform official duties. Common mistake: confusing surety bonds with E&O insurance. A surety bond protects the public, while errors and omissions insurance protects you from liability. For the next lesson, we will learn how to obtain and file a surety bond. Here's a step-by-step procedure. Determine if your state requires a bond. Not all states require it. Some may have other forms of financial security. Choose a licensed bonding company. You must obtain the bond through a provider licensed in your state. Purchase the bond. Provide your commission information and payment. The bond term often matches your notary commission term. Receive bond certificate. This document proves you've secured the bond. And last, file the bond with the county or state. Submit the original bond certificate along with your oath of office. Exam tip. A common test question: who is protected by a notary surety bond? Answer is the public. For the last lesson, we'll go ahead and provide real-world application example. Here's an example scenario. Maria has just been appointed as a notary in California. She must schedule an appointment with her county clerk to take her oath, Bring her $15,000 surety bond to file alongside the oath. Pay the filing fee. Only then can she officially begin notarizing documents. Let's have a mini check. True or false? The oath of office must be taken and filed before you can legally perform any notarial act. Answer is true. You are not an active notary until these steps are completed. Final recap. Here are some key takeaways we have learned from this lesson. The oath of office is a legal requirement in most states and must be filed within a specific time frame. You usually take the oath in person and file it with the county clerk. A surety bond protects the public from notarial misconduct, not the notary. Not all states require a surety bond, but many do, e.g., California, Texas. Filing your oath and bond together is often required to activate your commission.